morning, or good afternoon, depending on where you are today. My name is Kim Wilcoxon, and I'd like to welcome you to today's webinar. I'm a partner in the Employee Benefits Practice of the Cincinnati office of Thompson Hine, and I'm pleased to say I'm joined today by the newest member of our team, Avery Ozimek, an associate in our Cincinnati office. Today, Avery and I will provide a general overview of the Consolidated Appropriations Act, or CAA, and the health plan compliance issues employers need to consider. This webinar is the first in a series of 6 webinars that we're planning to present on the 4th Wednesday of every month at noon through August. Each webinar will explore a different CAA-related topic, including mental health parity, transparency, surprise billing, and more. So join us monthly, or just for the topics of interest to you. You can register through the invitation you received or through the Events tab on the Thompson Hine website. And we will be sending a copy of the recording of this seminar after the webinar is completed. Should be about approximately 2 business days. During today's presentation, please feel free to use the question panel at the upper right-hand corner of your screen. Send us the questions, and we will attempt to leave some time at the end to address those questions. If we don't address those questions, note that our last webinar in the series, which you don't have to wait this long, but the last webinar in our series is going to be a Q&A session. So if you have questions that come up as you listen to this webinar or our future webinars, keep them in mind for our last session. During today's presentation, Avery's going to start off with an overview of the Consolidated Appropriations Act and the Transparency and Coverage Rule, and really what the requirements are for group health plans. Then I'm going to talk a little bit about considerations for contracting with third-party vendors. What you'll see today is that most of the requirements that are applicable to group health plans really need to be satisfied by vendors. And so how do we contract with vendors to ensure that they will help keep our plans in compliance? We'll look both at immediate concerns for contracting and also some long-term strategies to consider. And finally, we'll review potential issues for revisions to SPDs. With that, I'll turn it over to Avery for an overview of the Consolidated Appropriations Act and the Transparency and Coverage Rule. Avery?
Hi, everyone. So I'm going to start with an overview of the requirements under both the CAA and the TIC rules. And I really think it's easiest to think of the requirements in these 3 buckets, so the 3 columns on the slide. So first, the surprise billing protections, then the transparency and reporting coverage, whether they come from the CAA and the accompanying rules there or the transparency and coverage rules, and then mental health parity. And I'll go through them in detail in the coming slides. So first, the surprise billing protection. So what are the protected services under surprise billing protections? So the protections under this rule are effective for plan years that begin on or after January 1st of this year and apply to the 3 categories in purple on the screen. So the emergency, out-of-network services, those non-emergency services provided by non-network providers at certain network facilities, when notice and consent requirements have not been met. And then finally, out-of-network air ambulance services are also protected services under this new rule. And then there are cost-sharing requirements. So for plans that began prior to January 1st of this year, when someone was using an emergency service, a participant's cost share had to be no more than the in-network cost sharing for that same expense. But it was a little bit different when there were non-emergency services, and the plan could set the cost sharing, and it could be higher than the cost sharing that was required for those in-network services. But now, for plans starting January 1st or later, when an air ambulance service is used, the cost sharing needs to be the same as the in-network cost sharing for the same expense. And also, the cost sharing amount needs to be calculated based on the lesser of the actual bill charges, or this concept called qualifying payment amounts, or QPAs. And then for the other protected services, so those out-of-network emergency services or those non-emergency services by non-network providers at certain facilities, when those are used, the cost sharing needs to be no more than the in-network cost sharing for the same expense. And also, the cost sharing amount needs to be calculated based on this idea of the recognized amount. And so now you might be thinking, what are these QPAs and recognized amounts? So QPA is generally the median of the contracted rates for a specific geographic region and for similar items and services that have been used. So if we're using air ambulance services as an example, this could be the lower cost sharing amount, since this could lower that cost sharing amount, since it would need to be the lesser of what's actually billed or the median contracted amount for that air ambulance service across that region, which is very likely going to be less than an out-of-network billed amount that they could receive. Now, the recognized amount is a statutorily defined term, but will very often come out to be this QPA, because at first we're going to look to see if there is an all-payer model agreement, which is really just an agreement between CMS and the state to operate in a system of all-payer payment reform. Most states don't have these, so then we move on to the next step. So if there isn't this all-payer model agreement, then we are going to look at the amount determined by state law. Again, this probably isn't going to apply in most situations, particularly for self-funded plans. So if there isn't an agreement, if there isn't specified state law, then we use this QPA or the billed amount, depending on which is lower. Generally, that's going to be that QPA, that median that we just discussed. So then we have provider payment requirements. So prior to plan years that began on January 1st of this year or later, there were minimum payment requirements for emergency services at non-network providers. However, there was no minimum payment requirement for non-emergency services, and the emergency and non-emergency situation, the provider could balance bill the participant for that difference. But now, under the NSA, for emergency services, the provider can't bill the participant, and the plan has to pay the non-network provider one of the three on the screen. So the amount set by the state, or state law, or the all-payer model agreements, or if there's neither of those, then the amount that's agreed upon between the plan and the provider, or if no agreement is reached through the process that we'll talk about on the next slide, then it will go through this binding arbitration, this IDR. But a big takeaway here is that providers now can't balance bill participants like they used to. So we just discussed the payment requirements, but what does the process look like, and how do the providers and plan reach those agreements? So first, the non-network provider submits the bill to the plan for the service. Then, no more than 30 days after the bill is transmitted, the plan provides either that initial payment or a notice of denial. If this is accepted, this payment, then great, the process can be done. But then if the provider doesn't accept, then we have to move on to the next box. So again, if these negotiations end before the 30-day requirement, or an agreement is accepted, great, the process is done again here. But if they don't, then we have to move on to the third, that last box. So the IDR process would then begin. So now you might be asking, what is this IDR process? So first, each party will submit what they want to pay, what they think is an agreeable amount, and the information to support that amount. Then the IDR entity, who's kind of like the mediator, considers each of the offers that have been submitted, the QPA, and then other circumstances surrounding that service. If there is some information that the IDR entity can't consider, these are things like the amount that the provider would have billed if the NSA didn't apply, or Medicare payment rates. Those can't be considered while the IDR entity is making their determination. Then the IDR entity will pick one of the offers, and the party whose offer was not chosen will pay the fees for that IDR process. The party that needs to pay then does so, and that information will be reported and published through HHS. The external review application is a really important piece of both this, the CAA and the ACA. So the ACA requires that non-grandfathered plans provide external reviews of claims involving medical judgment and rescission. The ACA then extends the availability of this external review process to claims subject to surprise medical bill or surprise billing requirements. So think again, those out-of-network emergency services, those non-emergency services at certain facilities, and air ambulance services. And as a reminder, this applies to grandfathered plans as well. So this becomes particularly important when we're thinking about what emergency really means under these new rules and under the ACA. So the definition hasn't changed between the ACA and CAA. Both use this prudent layperson standard, which really means that you, as a non-doctor, average person, if you would think that medical concern would constitute an emergency and you would go and seek emergency care for it, those services and post-stabilization services should fall under the protected service, even if the diagnostic code that the hospital ends up using doesn't show an emergency actually happened. Recently, we have heard that a TPA has let a client know that they would be adjusting some of their processes and benefit plan designs to ensure that they're capturing this new prudent person standard. And then an example of how this external review application is so important in real life. I recently read an article about a family who in the spring of 2020 had an expectant mother of twins who began experiencing dangerously high blood pressure, which presented an emergency for both herself and the twins. And because of that danger, her doctor ordered an emergency delivery at an out-of-network hospital. And the twins had to remain in that out-of-network hospital in the NICU for several weeks, which resulted in, as you can imagine, really high medical bills that were balance bills because the emergency care that the family received didn't have a diagnostic code that it came through an emergency room. So after a really long road of trying to fix this problem, the family finally paid an independent company to resolve the problem. However, on appeal, and then an external review, this could have been an imperative piece for this family to use to resolve the problem because the external review process would have used that prudent layperson standard. So transitioning a little bit to kind of the next bucket from the first three that we talked about at the beginning into the transparency and reporting requirements. So remember, there are two places that these transparency and reporting requirements can come from, the CAA and TIC. As background to the transparency and reporting requirements, the CAA and TIC rules impose significant number of new reporting and disclosure requirements, but of course they don't want to make it easy on us, so the effective dates of these may vary from requirement to requirement. Luckily, we did get an implementation FAQ, which was part 49, that provided certain relief, some effective dates, and some offered this good faith compliance standard that we'll talk through, and I'll make sure I note on each of the requirements that we talk to. Also, most of these will be discussed in our upcoming webinars in the series, so I'm going to do a pretty brief overview of most of these, and more will come with the next pieces of the series. So first is balance billing disclosures. So for plan years beginning on or after January 1st, which is a date that you will hear come up throughout this, Plans need to provide information about the surprise billing requirements that we just talked to ensure they are, one, publicly available, two, posted on public websites of the plan, and three, included in each EOB subject to the surprise billing requirements. But because of FAQ 49, there is this reasonable good faith standard that applies to this. So practically, you may not have this posted on a public website, and until we get more guidance from the regulators on what this really looks like, using a good faith, reasonable effort to make sure you're complying with this is the best course of action. So maybe that's posting on another website or making sure you include these in your EOBs. Then we have our provider directories. So for plan years, again, beginning on or after, again, this January 1st, 2022 date, plans need to establish a process to verify provider directories according to certain time requirements. They need to establish protocols, host a database, and have disclaimers, among other things. Again, here, there's that reasonable good faith interpretation so that January 1st date is still the effective date for this requirement. Then we have our ID cards. So again, not to sound like a broken record, but the ID card requirement will begin starting on or after this January 1st date, and plans will need to include certain information on their ID cards like applicable deductibles, applicable out-of-pocket maximums, and information where participants can get consumer assistance information for locating things like hospitals and urgent cares that they can use. Again, reasonable good faith interpretation to apply this until we get more guidance from the regulators. Continuity of care. So again, for plan years beginning on or after January 1st, if a plan and provider terminate their contractual relationship, so the provider is no longer in network, while a covered person is a continuing care patient, the plan needs to notify that person about the termination and let them know that they have a right to elect to continue transitional care with that person, even though they are that provider, even though they are no longer contracted with them. And if the person elects to continue treatment with this person, the provider needs to allow that in-network service for 90 days. But the requirements won't apply if the termination of that relationship is due to poor quality standards or fraud. Then we have the machine readable files, and these are those transparency and cover requirements. So this will begin when, on or after January 1st, of course, that date that keeps coming up, for plans to make publicly available 3 main machine readable files. So the first file is in-network rate files, then allowable amount files, and prescription drug files. All 3 of these have been delayed, their date, and the prescription drug file has been delayed indefinitely until we get further guidance, which we just don't have yet. And with that being said, these files really aren't meant to help one particular participant, but they're really there to help researchers aggregate data and determine solutions and look at healthcare costs to help participants generally. Whereas on the other hand, the self-service price comparison tools are really the other side of that coin. So these are here to help particular participants compare pricing and make educated decisions on their healthcare. Both the transparency rule and the CAA have a lot of overlap and are really similar. Under the transparency rules, the tool will be required to allow participants to obtain advanced estimates of costs and compare costs and provider options. And this will need to be available online or hard paper copy when requested. Now, under the CAA, the tool will allow participants to compare amounts and cost sharing and what would apply to specific items and specific geographic regions. And this needs to be available again online or telephone. So there's a lot of overlap that you can see there. The impact of the FAQ is that it was delayed until January 1st of 2023, and this is going to give the agencies a little bit more time to determine how to align these two rules since they are so close, but there are slight differences. Then we have the advanced explanation of benefits. So again, this will begin on January 1st, or was supposed to begin on January 1st of this year, but not really because the FAQ delayed this pending final regulations. So if a patient were to schedule a service at least 3 business days in advance, both the plan and the provider have certain requirements that they need to follow. So again, this will be important to review more thoroughly once we have those final regulations. Until then, we don't have a date that this will become effective, so it'll be important down the road to make sure you're following up with this item. Then we have the prohibition on gag clauses. This officially went into effect December 27th of 2022 and requires that plans not enter into agreements that would restrict the plans from providing provider-specific cost and quality of care data, electronically accessing different items for claims, and sharing that information with business associates. This applies to several types of organizations. So these are TPAs, healthcare providers, and other service providers offering a network of providers. Plans should also remember that annually you should be providing attestation that the plan is in compliance. Again, this one didn't have an effective date relief, but did have a reasonable good faith interpretation. Then we have our compensation disclosures, and under this, covered service providers need to provide certain compensation disclosures for plans. So covered service providers is a really broad definition under the statute. It said that vendors that provide any brokerage services or consulting fees will fall under this and need to furnish disclosures to those plans. So it's really broad what that will actually mean, and Kim will talk through that in the second half of the presentation. Covered plans include accepted benefits and retiree-only plans as well. And then disclosures need to be provided in advance of any agreement entered into or renewed on or after December 27th, 2021. So some of these have probably already been given out to plans, depending on your renewal date or the date you entered into it. Then we have our prescription drug reporting. So this requires that no later than December 27th of 2021, so a few months ago, and then by June 1st of each year thereafter, that plans submit pharmacy benefit and drug cost information to the agency. These dates have shifted a little bit. So the FAQ now says that this drug reporting will be due December 27th of 2022, but that doesn't mean that the reporting that should have been done December of 2021 and then that should have been reported in June of this year don't have to be reported. It's just that those are pushed back until December of this year. And then all of the purple boxes on the slide are the information that need to be reported in each of these reports in December and June of each year. Then we have our air ambulance reporting. So group health plans need to report certain items about air ambulance usage. So within 90 days after the last day of the first calendar year, beginning on or after the date the final regulations are promulgated, claims data for air ambulance services should be reported based on things like the type of aircraft that was used, the type of program the provider is a part of, if the service was emergency or non-emergency. And then within 90 days after the end of the calendar year, immediately after the year described above that I just talked about, the information described above for that reporting year. So the way the proposed regulations impacted this is that 2022 reporting will be due in March of 2023, and then 2023 reporting will then be pushed back to March of 2024. Then we have mental health parity, and I'm going to really quickly go through this because we have a whole webinar in the series in April that will be devoted just to this really important topic that questions come up and there's a lot of confusion, and we will really dive deep at that point. But for now, just as an overview of mental health parity and this new analysis requirement. So group health plans that are subject to MAPIA need to perform and document comparative analyses of the design and the application, so both of non-quantitative treatment limitations, or these NQTLs, which I'm sure is an acronym that you have been hearing quite a bit now. So this began in February of last year, and group health plans need to provide the DOL when the DOL requests it with a written analysis that needs to contain pretty specific information. So you can't just submit to the DOL conclusions that say, yes, we meet all of the requirements under mental health parity. You need to have specific findings with detailed conclusions of why, evidentiary standards, the factors that were used to determine the outcomes, things like that. A lot of this information is information that the group health plans and employers just don't have. So a lot of the heavy lifting here is going to need to be on those TPAs who do have that information, or other groups who have that information and are able to support employers in completing this comparative analyses. And then here's a general overview of what the process will look like for this mental health parity requirement. So taking a step back from even what's on the timeline, the DOL expects plans to have already done this NQTL analysis so that when the DOL requests that information, so that first bullet point on the timeline, the plan can quickly provide that analysis to them, because in the DOL's eyes, it should have already been done. So then once the plan provides that analysis, the DOL will determine compliance or non-compliance, and the plan will need to submit the updated analysis within 45 business days if they're found to be non-compliant. Then finally, if the DOL still determines non-compliance, the plan, even after an updated submission has been made, the plan will need to notify covered individuals of non-compliance within 7 days. And again, this is a lot of information to narrow down into 2 slides, and it will be a much longer, deeper discussion when we have the mental health parity episode of this series. And so I'm going to turn it over now to Kim to talk about some of the considerations based on this overview.
Thanks, Avery. I know a number of my clients have been getting draft contract amendments from their TPAs. Some of them have not heard a word from their TPAs about contract amendments. Some of them I've encouraged very strongly to ask for contract amendments, but hopefully, you don't have this already done and completed. It's something that you're working on right now or looking to do in the future. So we thought what we'd do is sort of talk through things you should be thinking about as you're working through contract amendments with your vendors. As we mentioned, and as you could tell from Avery's overview, most of these requirements are not requirements that you can meet on your own as an employer plan sponsor. Really, the vendor is in your TPA, your insurer, is in the best position to provide these services. So it's important to know what services are they planning to provide, and even more important to know what services are they not willing to provide. Most TPAs that we've seen to date really are expecting to perform most of the CAA services on behalf of group health plans, although there is varying levels of cooperation when it comes to the mental health parity analysis. It's also important to know to what extent separate vendors are going to collaborate if necessary. And thinking through these requirements, probably the only one that might require collaboration would be the prescription drug reporting. If you have a self-funded medical plan with a carve-out PBM, prescription drug reporting will require you to report prescriptions under both aspects of your plan. Now, the proposed regulations that have been issued so far seem to suggest that the departments will accept separate reports from the medical TPA versus the PBM. Hopefully that will be the case. If not, there may need to be some collaboration, and in your contracts, we want to leave that door open if necessary. So thinking about the services, what we sometimes see in these contract amendments are references to the CAA sections. So we will conduct surprise billing in accordance with sections 102, 103, and 105 of the CAA. So I thought what we could do here is sort of an at-a-glance chart of what are the sections of the CAA, what is the requirement. So as you're working through those contract amendments, you want to be sure that each of the services that you expect the vendor to provide are included either by name or by section number. So you might be thinking at this point, well, some of these requirements aren't going to come into play, until a later year or, maybe never. Should we at this point be trying to encourage our TPAs to agree to perform all of these services, even if, for example, air ambulance reporting, that's not going to occur this year? And certainly that's a strategic decision to make. I would encourage you to the extent possible to get all of these services, get a commitment from your vendor to help perform all of these services, because if we get to 2023 and we don't have a contract amendment in place, there's nothing that obligates that vendor to perform those air ambulance services. Do you want to get back to them, and negotiate this again? Speaking of that aspect, you may be saying, well, why do we need a contract amendment? Reason being, most of these services, well, some of these services, I guess I should say, are not services that the vendor would be required to provide in order to administer your plan in compliance with the law. So, for example, that air ambulance reporting. They are not required, most likely under the terms of your contract, to provide air ambulance reporting, to provide data to the government to satisfy this requirement. If you want that vendor to do that, you're going to want a contract amendment in place that obligates them to do it, and to do it in a manner that allows your plan to comply with the law. Now, you may be thinking, well, I have an insured plan. Should I really be thinking about contracting? Can I zone out for a little bit more of this presentation? And I would say at least pay attention to this slide, because there's a provision in the transparency and coverage regulations, in the proposed prescription drug reporting regulations, and in the proposed air ambulance reporting regulations that allows you to get off the hook if you have a contract in place with your insurer. So if a fully insured plan has a contract with an insurer that obligates the insurer to satisfy these requirements on behalf of the plan, and if the insurer doesn't do so, it's the insurer's obligation, it's the insurer's responsibility, it's the insurer's liability, and you are found without fault. Contrast that to a self-funded plan. Certainly you can have a contract in place that obligates the vendor to perform these services for you, but if the vendor doesn't do it in a compliant manner or doesn't do it at all, the plan is still on the hook. So even if you have a fully insured plan, or if you have fully insured plan options, you want to think about getting a contract that obligates the vendor to perform these services for you. Now, some immediate concerns, continuing this thought to think about when you're negotiating amendments right now, to what extent does or should the plan have the ability to direct the vendor's compliance? So think about the surprise billing process that Avery described. The vendor is going to propose an amount of payment to the provider. So we're in a negotiation phase. How much the vendor proposes might impact whether the provider accepts that or not. If the vendor proposes an amount that's higher than maybe would have been accepted, then the plan is out money that it otherwise wouldn't have had to pay. Whereas if the vendor proposes an amount that's lower than what might be accepted, that might drive the provider to arbitration, which could then increase costs further for the plan. I think at this point, we're still early enough. I don't know if we have enough data to really understand what an appropriate negotiation strategy would be. So I don't know, to what extent you would want to be able to direct the provider on how they're going to exercise that negotiation strategy. And I can't tell you, is a TPA going to even allow you to direct that? What I can tell you is of the amendments that I've seen, some of the TPAs do not provide any sort of option for the employer to get involved in the compliance, right? It's the vendor's going to handle it. They're going to handle it pursuant to their standard processes. I did see one amendment that restricted the vendor's ability to negotiate and said the vendor can only offer up to 110% of the QPA without consent from the employer. That vendor clearly was trying to limit its role as a fiduciary. It says, I'm not a fiduciary. I don't handle second-level appeals. I don't have unlimited discretion to determine how much to offer to this provider. I'm going to just follow your direction, employer. So a couple different approaches here. Think about what you might want to have and what your vendor's willing to allow you to have in this respect. Now, this is an immediate concern because you may want to direct the vendor now, but as we get into longer-term considerations, you might want to preserve that right to direct them down the road. Also, think about to what extent will the vendor provide reporting or copies of required reports. This, again, we'll talk about in a minute in the long-term strategies, but you might think about this now so that you get it into the contract, so you leave the door open for the vendor to provide you information that you might want down the road. Obviously, an immediate concern is what fees will apply. Is the vendor going to increase the PEPM administrative fees because of these new requirements? Most of the contracts we're seeing, the vendor is not doing that. Most of the contracts we're seeing, the vendor is passing through the government IDR fee and the fee for the IDR entity. So that fee that applies during arbitration and then the separate fee that goes to the government, those fees are very routinely being passed along to employers. Some TPAs we're seeing charge additional fees for the negotiation above and beyond whatever the IDR might be charging. And then the last thing to think about is shared savings fees. So your contract very well right now may have a shared savings fee component. So for example, a provider bills $30,000 for a particular service. The plan determines that its initial payment is $5,000. Obviously, the provider is not happy with that, so they enter into negotiations. We determine that the QPA, that median contracted rate, is $7,000, and the vendor ultimately gets the provider to accept $10,000. Under a shared savings fee model, this negotiation strategy, the vendor just saved you $20,000, the difference between what the provider billed and what the provider ultimately accepted. Does the vendor get a cut of that $20,000 as payment for negotiating? That's something you'll want to understand as you're thinking about fees in this contract amendment. Now, what protections will apply if the vendor doesn't comply? So as I mentioned, for a self-funded plan, if the vendor doesn't comply, if the vendor doesn't address the requirements in a manner that allows the plan to comply with the law, then the plan is on the hook for violations of the law. So if it's not clear in the current amendment, you want to take a look at your current agreement. What does the current agreement say about compliance with the law? Does it say each party will comply with all applicable laws? Well, that very broad statement might be read by the TPA to say, I'm going to comply with laws applicable to a TPA. I'm not a plan. I'm not an employer. I don't have to comply with laws applicable to the plan. So if I conduct my business in this manner and it doesn't happen to satisfy the CAA, that's not a violation of the contract because that CAA doesn't apply to me. So what I like to see in contracts is a requirement that the vendor administer the plan in a manner that allows the plan to comply with the law, and that the vendor is not going to take any actions or have any omissions that would cause the plan to violate the law. It's a little bit of a nuance that you may want to look at here. You'll also want to think about the current agreement's provisions on indemnification and limitations of liability. Again, if the vendor is not complying and it's the plan that's on the hook, does the plan have any recourse against the vendor? If that's not clear or not clear enough in the current agreement, that may be something you want to try to get into this amendment. Now, it's not necessarily just sort of violating the law, but I wanted to point out something that Avery didn't focus on when she talked about provider directories, which is this concept that if an individual relies on the directory to think that a provider is a participating provider, and it's wrong, right? The directory wasn't updated, the directory was wrong for some reason, the participant gets to treat the services as in-network services, even though the provider is out of network. Now, this doesn't obligate the provider to do anything different. There's no protection against balance billing here. This is just a general statement that if the directory is wrong, the plan has to give the participant the benefit of the in-network treatment. That could very well mean that the plan is not receiving as much cost sharing from the participant as it could. It may mean that the plan has to pay the out-of-network provider a higher amount than they otherwise would have. So there could be some additional costs that come along with not just, a blatant failure to comply with the CAA, but something like this where they just haven't gotten the directory updated quickly enough. Of the reviews that I've done so far, I haven't found a contract that would protect the plan in a situation like this. And my guess is you won't get a TPA to agree to protect the plan in a situation like this. This is more, routine updates, negligence at the very worst. But something like this, you should at least be aware of as you're thinking about, what happens if the vendor doesn't comply. A few other immediate concerns as you're thinking about these amendments, are the data protection provisions of the agreement, the current agreement with the TPA, sufficient? A lot of this information is going to be electronic. And so if you haven't looked at your agreement for many years, if we haven't, the data protection provisions are out of date, or maybe you don't have any data protection provisions in your contract, this is a good opportunity to get in there, update your data protection provisions, and make sure that your plan is protected and that the vendor is doing what they need to do to secure the information, even when it's electronic. Another thing to think about is this amendment a renewal or extension of the agreement? If so, and you're doing it right now, this is a renewal or an extension after December 27th, 2021, which means that the compensation disclosure rules will apply. So the question becomes, if you're negotiating with a medical plan TPA, if you're negotiating with a PBM on these services, is the TPA or the PBM a covered service provider that's required to provide these compensation disclosures? As Avery mentioned, a covered service provider is one that's providing brokerage services or consulting services. So you wouldn't think that a TPA or a PBM would be providing brokerage or consulting services. But the definition of those services in the law is very broad, and it arguably could encompass a medical plan TPA or a PBM. Now, I understand that the TPAs right now are lobbying hard to the Department of Labor to get the Department of Labor to clarify that no, they are not brokers, they are not consultants, they are not subject to these compensation disclosures. But as of right now, we don't have that guidance, and we're required to move forward with a reasonable good faith interpretation of the compensation disclosure rules. So, if you are renewing or extending your agreement at this point, and we don't have the guidance to say that the TPA is not a covered service provider, ask them for the compensation disclosures. And if they say no, ask them why they won't provide them. If you don't think you're subject to this requirement, explain to me why. And then you've got something, good faith compliance, you can put in your file, assuming that it's a reasonable explanation, to show that you tried, but you're not going to pursue this any further because you have a reasonable good faith interpretation that the rules don't apply. You'll also want to check to see if the current agreement includes any gag clauses. If so, we want to make sure we take that out. I'm routinely trying to put a provision in contracts and amendments that says, notwithstanding anything to the contrary, this contract will not prohibit the plan from X, Y, and Z. And that way, don't have to go hunting through the contract, don't have to worry about what in the contract might be viewed as a gag clause or not viewed as a gag clause, but certainly something you want to make sure you don't have any in your contract. Now back to services, there will be a requirement to attest to the government that your contracts do not contain gag clauses. we're seeing in some of the TPA amendments, an agreement to provide information to the employer as necessary to help them make that attestation. So you may want to think about that. It's not the vendor agrees, not to comply with the gag clause requirements. They may need to make disclosures to you to help you do that attestation. If you've not seen guidance yet on that attestation, how to make it, what it will include, that's something we need to keep our eyes open. And then what happens if the vendor is just unwilling to contract? We're seeing this where vendors are not providing contract amendments. Certainly, you could propose an amendment. We've developed one here at Thompson-Hein we call a memorandum of understanding, which is essentially you, vendor, agree to comply with X, Y, and Z, all the requirements on behalf of the plan, and we can work out the details later. But in the meantime, you're going to act in a manner that allows our plan to comply with the law. If the vendor doesn't, give you a contract amendment, doesn't entertain a contract amendment that you provide, then what you have to do is think about, okay, well, what could our current agreement cover some of these things? To what extent are services arguably covered? Probably the surprise billing services are covered because the contract most likely requires the vendor to administer your plan in a manner that complies with the law. We have a change in the law, a change in the way the plan has to be administered, so the vendor should be following that. What are the indemnification and limitation of liability provisions? If the vendor doesn't comply, do we have protections? Or are we sort of left in limbo if the vendor doesn't do these things and we don't have a contractual right to enforce them to do so? And does the vendor have the ability to adjust fees based on changes in legislation? Given that this is a new law with lots of new requirements, it would be very reasonable for a TPA to say, hey, this is a lot of extra work, I need extra fees. There may be a provision already in your agreement that allows the vendor to adjust the fees without your consent in connection with that change. It's something to be aware of as you're going through this. And if the vendor is simply unwilling to contract, worst case scenario, consider whether an RFP may be appropriate. This is has come up in light of the mental health parity requirements, where vendors are being I will say they're becoming more and more willing to provide more and more information. But at the beginning, there was a concern that we weren't going to get the information we needed from the TPA. And when we raised this issue with the Department of Labor, what are our fiduciary obligations if we can't get this information from the TPA? And the Department of Labor said, well, are all the vendors being unwilling to comply? Are there some that are really willing to comply and some that are really obstinate? If you've got one of the obstinate vendors and there are other vendors who are willing to help, maybe you have a fiduciary obligation to look at switching to one of those other vendors. So something to think through. And if you do conduct an RFP, that's a great time to exercise leverage to say, I expect you to do X, Y, and Z. I expect you to have this provision in your contract. These are the limitations of liability that we're willing to accept. Put that out as part of the RFP and see what vendors, bite at the front end. That's where you have the leverage to get this stuff into the contract. So thinking for a minute about long-term strategy, what is going to be the financial impact of the No Surprises Act? Is there going to be an impact to how the vendor calculates the QPA or what their negotiation and arbitration strategy is? Are you ultimately going to want to be able to direct them because you can see a significant difference based on one strategy versus another? That's something that I think we're going to need some sort of additional information on. And we are going to have a deeper dive on the No Surprises Act and hopefully may have some financial data and analysis available at that time. We're pushing this off until July, hoping we get some data by that time to sort of think through what are the financial impacts and should we be doing anything differently. You may also want to think about the vendor's negotiation activities outside the No Surprises Act. We started discovering a few years ago that vendors were conducting negotiations with out-of-network providers, in cases where the client didn't even know that that was the case. When an employer designs its plan within network and out-of-network and has certain plan provisions for what the plan will pay in network and out-of-network, and then the vendor decides to go and negotiate with the out-of-network provider for a payment that's going to be higher than what the plan had intended, the self-funded employer should be aware of that, because that's the self-funded employer's money that's being negotiated away. Are we willing to do that in order to protect our participants from balance billing? And is that still appropriate in light of the No Surprises Act? Should there be other circumstances where the vendor can do this type of negotiation with out-of-network providers? And should they get a shared savings fee for doing that? Something to think about as time goes on. You also may want to consider whether fee structure in general is appropriate for TPAs and brokers and consultants. Those compensation disclosures may or may not give you information to help you decide whether a change is appropriate. You may want to change that shared savings model given the requirements of the NSA. And consider whether or how to use data from new transparency requirements. There's a lot of good information in the prescription drug reporting that will be provided. Unfortunately, the proposed regulations allow PBMs to report sort of generally based on their book of business as opposed to specifically with your plan. So you may not get that information specifically for your plan. You may want to ask the provider to provide information specifically for your plan. They very well may object, they may refuse, but it may be worth asking. And then you can see that data down the road to determine whether any changes should be made to your plan or the way it's administered. Moving now to the last section of our webinar, which is what to think about with SPDs. So clearly, as Avery mentioned, there are changes to the way the plan is administered under the No Surprises Act, right? We've changed the way we address cost sharing for the protected services. So in the SPD, if the SPD says, co-insurance is the percentage of the recognized charge that you are required to pay, well, that definition of recognized charge, which used to be UCR or 110% of Medicare or whatever the plan has, that's not going to be accurate anymore for the way we calculate co-insurance for a protected service. Similarly, the SPD most likely describes how the plan determines how much to pay to an out-of-network provider. Well, under our No Surprises Act protected services, that payment is going to be different. So the language of the SPD that currently exists probably isn't consistent with how we're actually going to determine the payment to an out-of-network provider. There may be references to balance billing in the SPD that say, if you choose an out-of-network provider or if you use an out-of-network provider, you may be required to pay the balance of the bill between what the provider charges and what the plan pays. We may need to put a little, except for the protected services in those types of references. Definition of emergency. As Avery mentioned, the concept of an emergency health condition, is still basically the same as it was under the ACA in that we're using a prudent layperson standard to determine whether an emergency health condition exists. But the emergency services that are provided in connection with that emergency and that are subject to these protections are a little broader. We're now including services from an independent freestanding hospital facility. We're now including certain post-stabilization services. So you may need to look to the SPD to see how does it use the term emergency or emergency health services or emergency medical condition? And do we need to adjust those provisions to reflect the new provisions of the NSA? Continuity of care provisions. Avery talked about the disclosures that have to be made to someone who's a continuing care patient when their provider leaves the network. But in connection with that, the participant has the ability to elect to continue that treatment as in-network treatment for up to 90 days. The SPD may have a section that talks about continuity of care under certain circumstances. We may need to broaden that to include the NSA provisions. Or maybe there is no continuity of care language in the SPD, and we want to add it to reflect the NSA. Similarly, with provider directory, there may be a section of the document that talks about the provider directory. We might want to add language to say, if the provider directory is wrong, if you relied on the provider directory and you were misinformed, as required by law, we will treat those services as in-network services. So you're providing, what the requirement is. We're willing to do what we're required to do, but only that. We're not going to give you any more just because you happen to look at the directory and it was out of date. Services eligible for external review. As Avery mentioned, the question as to whether the plan has appropriately applied the No Surprises Act is now eligible for external review. So the SPD most likely says external review is available only for medical judgment or external or rescissions. We may need to add or claims subject to the No Surprises Act. And grandfathered plans, if you have a grandfathered plan still, we've got some new things that need to be added to the SPD. If you're not already voluntarily offering external review, the plan will have to offer external review for surprise billing claims. So you'll want to make sure the external review provisions, at least with respect to surprise billing claims, are in the SPD. And this is not something that Avery talked about, but the NSA took the patient protections provisions of the Affordable Care Act and moved them to a different section of ERISA and the code. Originally, the ACA said, we have these patient protections, not just with emergency services, but also, if a plan requires you to designate a primary care provider, you can pick any care provider that's available. You can pick a gynecologist, you can pick a pediatrician for children, and there's a notice that goes in the SPD to explain what those patient protections are. Well, the No Surprises Act, by picking that ACA language up out of one section of ERISA and the code and putting it in another, put it smack dab in the section that applies to grandfathered plans. So now grandfathered plans, if they require designation of a primary care provider, will need to also have that patient protections notice. That brings us to the end of today's webinar. We want to keep in mind, and I know we've said it over and over again, but we are definitely going to provide some deeper dives into other aspects, specific aspects of the CAA. So you can see here the dates and the topics. You can go back to your registration email or go to the Thompson-Hein webpage and sign up for these webinars. At this point, we've got a few minutes left. I'm going to take a look at some of the questions that have come in and address those. Easy one first. Yes, you all will get a copy of the recording. You all will get a copy of the slides. Those should be emailed to you automatically within 2 business days. Let's see. And then a question has come in. Pardon me while I take a minute to read this. We provide the Medical Network's website for provider directories for providers to look up to employees. Does this satisfy the provider directory requirement? Since Network is responsible for updating, can this be satisfactory for the updated provider directory? I'm not sure I fully capture the question, but I think the answer is, our network has the directory available and we point people to that. So you are required to have a database. I'm assuming that that provider directory is done through a database, and it does need to be updated. So the requirement is not only to have a directory, but to make sure that it is updated appropriately. And then the plan is actually required to reach out in certain circumstances to make sure that the information is correct. It's required to update the directory when it gets updated information from the provider. So the requirements really are more than just having the directory. So that's something you want to think about, again, as you're contracting and requiring whichever entity it is to provide the database and to make sure it's updated. What new requirements apply to retiree-only plans? Shoot, there is one that does, and I'm blanking on it right now. Avery, if you remember, jump in. But the No Surprises Act does not apply to retiree-only plans. Oh, it was compensation disclosures. Compensation disclosures apply to retiree-only plans, but none of the other requirements do. And I think that takes us to the end of our questions and the end of our webinar. So you will receive a very brief survey following today's webinar in your email. We'd appreciate you taking a few minutes to complete it. Our next webinar will be April 27th from noon to 1, and we'll address mental health parity compliance. So thank you for attending our presentation. Thank you, Avery, for your wonderful overview of the CAA. We'll send the recorded